We have Mr. Floresvaldo Florentino, Mr. Alan Damasceno, our Deputy Secretary General of the Association for the Prevention of Torture, Audrey Murat. She's here with us. Good morning, Audrey. I'm going to start. Sylvia, I'm going to leave right now and I will be back, okay? That's okay, thank you. Let's start our webinar. Firstly, I'd like to welcome you. Good morning, everyone. It's a great pleasure to be here, and I'd like to welcome you on behalf of the Association for the Prevention of Torture, APT, and you're here for the launching of our platform, Observa Custódia. I'd like to greet all of you who are here with us, and I'd like to greet our panelists that are going to participate in the two roundtables, and I'd like to extend uh, our thanks to our partners, the partners that were with us since the beginning. And before we start, I'd like to give two announcements. First, that the event is being recorded and that the video will be available later on our channels. And the second is that all the speeches are going to be in Portuguese, but we have simultaneous translation in English for those who are watching from other countries.
English translation. You just have to go below the screen and click on the globe that appears below and choose the English channel. So you can hear the entire webinar in English. And if you have any question about that, you can put in the chat so we can try to assist you. O objetivo do nosso evento hoje é
The
lançar.
objective of our event is to publicly launch our online platform called Observa Custódia, which is a result of a collaborative program developed by several hands with this exchange of ideas, reflections, and we intensively started working 1 year ago. And this platform is a tool for monitoring and data disclosure about custody hearings in Brazil using a methodology that is accessible, shared, and that will enable to share updated information, reliable information about custody hearings. We are going to have two roundtables today. In the first one, we are going to talk about the initiative itself, what it means in terms of data production and contribution for a greater transparency of the justice system and for enhancing the practices. And in the second roundtable, we're going to talk about distinct aspects and reflections upon the data we were able to survey. In this first round of data survey in which we were able to systematize different services and structures that we offer when we operate the custody hearings in the 26 capitals and the federal district. And after the second roundtable, we are going to have a Q&A session, and then we invite you all who are here participating to ask your questions, putting your comments or questions either on the chat box or in the Q&A box. You can ask or send your comments during the event, and we're going to answer after the second roundtable. So that's it for the moment, and without further ado, we are going to start with the first table, and we're going to introduce the first panelists. We have with us Audrey Olivier Murat, who is the Deputy Secretary General of the Association for the Prevention of Torture, APT. We have Florisvaldo Fiorentino Jr. He is the president of the National Council of Public Defenders and Defenders General, and also president of the Public Defender's Office in São Paulo, and Mrs. Janine de Carvalho. She is the executive secretary of the Criminal Justice Network. Welcome. And to start, I'm going to give the floor to Audrey Muraut. You have the floor. Thank you, Sylvia. Good morning, everyone. I'd like to greet you all, the speakers that are coming for the first roundtable, second roundtable. It's a great pleasure to be with you today. And I wish you have a great event, a very important event, that is the launching of Observa Custódia, a platform on the custody hearings in Brazil. It's a pleasure and an honor to be here with you for us to discuss about the data that we are disclosing today. From now on, the platform Observa Custódia is publicly available, and it's a tool for collective monitoring. Silvia Diaz, my colleague, has talked about that, and the collective aspect is very important for us to have objective data. It's a project that was made by many hands, and in its essence, it has a cooperative aspect. And that's why it's one of my uh, favorite projects here at APT. And I'd like to say that we started to think about this platform because a platform like that is so necessary. We had the emergency state of public health, and in the first moment, we had to suspend the custody hearings in all of the country. And in a second moment, we started this debate concerning authorizing or not the virtual custody hearings in Brazil. And we ended up approving that in the National Council of Justice with the resolution 357 from 2020 as a temporary measure as we had this calamity state. Many authorities, several actors, including APT, and many of the entities who are here represented participated in this process with advocacy concerning this subject to understand how this uh, virtualization could hamper the purpose of the hearings, because the hearings are guaranteeing fundamental rights. So we understood that there was not a single source that was authorized and public and easy to access, where to find information on how the public hearings were happening. We needed to map how the custody hearings were happening in Brazil. And that demanded many exchanges, many WhatsApp groups, and that was not sustainable for us to obtain information that seemed to be even simple. So that's when we understood that we didn't have a reliable source that was easy to access, that would enable the obtainance of information about custody hearings. And that was the great driver for us to think about what we could do to solve this problem. Most of all, we know today that data and information are key elements for the advocacy, for the mobilization of civil society, trying to change the practices in the justice system. And they're also a key source to foster public policies. The custody hearings are a recent element in the criminal justice system in Brazil, and its monitoring is helping us to have good practices. The collection and systematize of information concerning different realities in the country can provide subsidies that are useful to guide the development of the public defender's office, the public prosecution offices, and courts of justice in the country. Today, we have the results of 1 year of work. I won't talk about that because we have many panelists who are going to discuss about data, but I'd like to thank you, thank all our partners from the civil society, from the panel system, because you're helping us to reflect upon this tool and how it could be conceived. We've been thought about the objectives, the methodologies, what type of information would be available, and we did that for months over months before we had the platform. And this is a pilot project, and we want to have a second survey, but for this first survey that we have today, we count with this valuable partnership of the National Council of Public Defenders and Defenders General, CONDEG, who is supporting this initiative, and they are bridging the gap with different public defenders in each of the states. And you also requested this electronic form to collect information. So this collaboration had very successful results. We received responses from public defenders from the 27 federative units in the country. And this way, we were able to complete this national mapping for the first time. We had 26 capitals and the federal district participating. So I'd like to deeply thank you. Uh, I'd like to thank all the public defenders that dedicated their time to contribute for this effort of production and democratization of data. I'd like to emphasize that this platform is a tool that is constantly evolving. We are going to consolidate it and improve it over time. This first stage of data collection, we had the limit of information about the capitals and cultural aspects concerning the operating of custody hearings. For this next stage that is going to come soon, we wish that this consultation will come to the countryside of the different states, to regional hubs, so that we can map different subjects of legal character concerning the hearings, such as collecting the profile of different people concerning the race, gender, and so on. So the launching of this platform is happening in a very important moment for us. The data collection happened between July and September 14th this year. Before the decision of the National Council of Justice to return to face-to-face hearings. In this context, this platform is a timely tool that we can use to monitor closely how this face-to-face hearings are going to happen in different capitals in Brazil. So we praise this decision from CNG to go back to the face-to-face custody hearings. I'd like to deeply thank all the partners, entities, CONDEG, IDDD, ISE, National Justice, the Network of Communities and Movements Against Violence, Conectas, Pro Bono Institute, Asa Branca Criminology, Raju, Global Justice, and other professionals were working with us to make this platform a reality. We had a generous support of our supporter, Thinker Foundation Caroline. I know you're listening. And without you, we wouldn't have had this initiative. And finally, I'd like to express uh, my thanks to Silvia Dia and Fabio Cascardo, my colleagues who enabled us to have this platform today. Have a great debate. Thank you, Audrey, for your words, your opening remarks for this event. And I'm going to give the floor to Mr. Florisvaldo Fiorentino, who is representing Condege, an instrumental partner in this data collection so that the platform could become a reality. You have the floor. Thank you. Good morning. I'd like to greet everyone here, our speakers, Silvia Diaz and the other colleagues from APT, our colleagues who are public defenders, Mr. Rodrigo Pacheco, the Defender General in Rio de Janeiro, who founded this partnership between Condege and APT, and I'd like to praise this launching of Observa Custódia. It's the outcome of a research program that was very important, and we had many forces together, Condege and the other partners who enabled this very interesting outcome on the overview of custody hearings in different capitals in the country. Some of the outcomes, as we are going to see ahead, are very revealing. So this work was very important in this perspective of enhancing public policies. And it's also an instrument that is enabling the working of the criminal justice system, especially for the public defender's office. And it was strategic for us to work with this sensitive topic that was born also from the work of the public defender's offices in the country. So this is a timely launching because we had this recent change in the dynamics. We had to change the dynamics during the pandemic. We had virtual hearings, as we're going to see. And we had this special interest from the public defender's office because we have reliable data coming from this tool. And it's a tool that is going to add a lot to us and to our work. So I'd like to congratulate you, Sylvia, APT, and the other partners for the launching of this platform, the public defenders all around the country who helped us a lot by filling out the forms. And we want to delve deeper in this work so that this research can find different indicators enhancing the different territories beyond the capitals. And this is a work that we are going to develop, most certainly. And I'm sure that we are going to have great fruits from this work. Thank you so much. I'm going to give back the floor to Sylvia, and we move on with our event. Thank you, Mr. Florisvaldo Fiorentino. These are our expectations, that we can have this work tool that is useful for several sectors: civil society, public defenders, the courts, the public prosecution. It's a tool for us to improve our practice and develop different strategies. And it's coming in a timely moment, as you just said. We are going to have this change in these dynamics, and we hope to have face-to-face hearings again. And this is a tool for monitoring how this is going to happen in the next month. I'd like to thank you again for the partnership. Thank you for being here. I know that you have another commitment and you have to leave soon. So I'd like to thank you. I will give the floor now to Mrs. Janine Carvalho. She is representative of this criminal justice network, and she's a great partner as well in building this initiative. Mrs. Janine Carvalho, please, the floor is yours. Thank you, Sylvia. Can you hear me? Yes, we do. Good morning, Sylvia. Good morning, everyone here. I'd like to thank for the invitation. I'd like to greet my colleagues in this panel. And I apologize again because my camera is not working. It's not working now, but it hasn't been working for some days. So I apologize again, but I won't complain. Let's go on. As Sylvia just said, my name is Janine, and I'm representing the criminal justice network that comprises nine organizations from civil society, and we've been working for 10 years to reduce mass incarceration. I'm going to start to speak with the same sentence that I said to Sylvia and Fabio when they presented the results of the platform. It's a cheesy sentence, but that's true. I believe that this platform, Observa Custódia, is a dream coming true because it's translating a lot of the feelings that I had, that I still have. It's a dream that we've been waiting for during the pandemic, especially in the critical moments. As you all know here, during the pandemic, we had not only a poor prison system as a whole, but we had a poor access to justice, and we had the violation of inmates, people who were in prisons and that had their justice services very much curbed. So the custody hearings were dramatic at that time. The After this initial moment, people were trying to dismantle the custody hearings, especially the judiciary branch and also the legislative branch. And during the virtual hearings, the civil society has always lived with this great difficulty to obtain data concerning its functioning, reliable data, referring not only to custody hearing, but also to the general impact of the pandemic on the prison system. Many times, the data were different according to different sources. Concerning that, I believe that social society had a key role, a role that has been played for many years. It's not only happening now, because the lack of data is something chronic in criminal justice. Many times when they are produced, they need qualification, and they often do not disclose data. It's hard to analyze historic data, and it's hard to have public policies based on evidence. And in the specific case of custody hearings, it was a matter of dispute. And the implementation demanded a lot of resilience from civil society, but the poor data was remarkable at that time. We spent a long period without data, without official data on how they were happening, if if they were happening and if they were respecting the minimal standards imposed by CNJ.
Questionáveis por si só e tanto quanto alienados das realidades das comarcas brasileiras, né?
Questionable, depending on the state of the courts in Brazil. And by experience itself, we knew that things were not going well. We had a few records here and there of violations of the system. We had data showing the drop in the results. This is data brought by the Defender's Office in Rio de Janeiro, over 80%. We had the records of some cases in police stations, Pernambuco especially, and that were recorded by the policemen themselves or through cell phones. And in addition to these operational problems in custody, we had arguments from public defenders and other people that they would try to increase the access of poor people with arguments that were totally alienated from the reality. Even when we do not have this inequality, when we have access to the internet, you do not have any assurance that the process will transfer easily. And the case we had the idea that these virtual hearings would bring but we had no results, and no impact study was presented up to now. We do not have any budget study or record study, and this is important because this implies that some spending will stop because people being in prison continues to happen, and the whole structure would have to be created for custody agencies be developed. So there was no registration of that because all these adds up to something. What we saw is civil society that started producing data, and several initiatives were led, such as against torture through the National Agency, and the research done by Pro Bono Institute and other institutes, and the network of criminal justice itself, which reinforce what I said before, that agencies, custody agencies, that we have an absence of data on the part of civil society, and that often it's this society that tries to fill in those gaps despite its difficulties. And this absence shows neglect on the part of the state to fulfill its role, even though the efforts endeavored were very large. Civil society does not have the capillarity or the possibility of applying all this. And this is not our primary function either. Civil society should produce data and analyze it as a complementary action, not to the state's action. And this shows that they should be consistent, that we have the Observa Custódia platform, as I said, in which we observe the data, and we have participated in that. It's important to mention the collaboration that and say that it is Civic that led this project, and this proves everything that we said. At the end of the first semester last year, it was the first time that CNJ had official data on custodial hearing, and that was very late, actually. And the numbers were really something that was discouraging, and they just were the evidence of what we had already been saying, and they end up wrapping up the absence of the instrument itself, and they show the inequality of these, what happens in the capitals in the internal states. They did not respect the collection of data. And we had model of adhesion to the virtual model that shows the exception of the measure, and very clearly that they were exceptions, and in most cases they were end up not being treated like other violations, such as lack of privacy, the violations and others. And the data of the platform show that there was a dismantling of the custodial agencies, and I know that we will talk about that in the next table. And we see that we have only 29% of these agencies, which is a number closed of what Synergate had brought. But the platform has other advantages that for the moment has not shown yet. The first one is that it was a permanent platform, which will help us save a great deal of work, and having to gather data as have been taking place now, which is very important to make our situation more operational and feasible, and shows that the concerns are based on scientific data, and it's not just invented out of a concern on our part. And it shows that there is no transparent, lasting public policy, and also what is most important, and we insist on the importance of these custodial agencies that are showing they are exception, even when the exceptional situation no longer has any reason to be, and you have several sectors fighting for this to become a rule, which we had in the beginning. And finally, I think we have a recognition of partnerships with Public Defender's Office, which in addition to production of data and being an endless source of data, the Public Defender's Office was the main source for against violation of these custodial agencies, and we have been partners with custodial agencies, basing themselves also on the support of families, and have been following. They have been important partners against the dismantling of these custodial agencies, and I will prep in here, and I hope I have contributed a little, speaking on behalf of civil society, without, of course, being able to represent everyone, but saying that I speak from a place in which I work together with several other partners, and we have been working for a long time for the implementation and improvement of custodial agencies. I'm here for your questions if you have them. That's excellent. Thank you very much, Janine, for your contribution. And as I think that, as you said, a great deal of this void in data is when there was so much participation before of civil society at that moment in which you had a suspension of custodial hearing after the beginning of the health situation. It was, remember how difficult it was to obtain the data, and we know how much this data is important at the same time. And as you said, quite often, they are so much requested that civil society shows an interest in this. And this was one of the engines that motivated us to go ahead with the idea. And we hope the platform will be aligned with what you said, and that will be another engine to help institutions in the justice system to generate and produce these data and use them actually, so that there is more transparency in the system and also more democratization of the data, which we know are so important. And we hope that the platform will be there to help lead ahead these efforts. We will wrap up this first table, and I would like to thank you for, I'd like to thank Audrey, Florisvaldo, and Janine for the words. And before we move on to the second panel, I would like to remind you that we can ask questions and write comments on the chat. And we have this event in the format of a webinar precisely for that. So participation is through the chat. But we are paying attention to the chat, and we will answer as the event proceeds, and especially in the last half hour. So once again, I thank our partners and speakers for their partnerships, and I would like to thank them for the work, and also I would like to thank the network for the participation. It's a great deal of work to improve the new justice system. I'll now give the floor to Fábio. Thank you very much, Sylvia. Good morning, everyone who is here. Welcome to all those who are listening to us on the recording that is made available on the APT site. I would like to know if you can hear me well and you can see me well as well, because I cannot see myself on the screen, but I would like to give continuity to the event. And the second panel of our webinar has as a scope to talk about the 7 years of the custody agencies and to talk about the operationalization of the custodial agencies in the several Brazilian cities and the processes that are possible to identify through this monitoring that we see still in a pilot as a pilot system, but that has proved to be a sustainable model for us to be able to proceed with other studies and researches on the system. The idea of the second panel is to explore the data that we have found available. And since we have a great deal of data, we sent a form to the public defender's office so they could share with us their experience on public hearings. And we sent them 47 questions. So we have 47 graphs that are made available on the site for Observa Custódia. That's a great deal of data, and it's difficult to understand at first sight. And it's difficult to extract information. The idea is to share with you some of the main graphs and answer, but afterwards you'll be able to go to the site and find much more data than we're able to share here today with the help of our guests in this panel. And because of that, we have formulated some questions to the guests of the second panel. And these questions were sent beforehand so they could go in depth into the subject. But of course, they are free to talk about the custody and other things related to the topic and based also on their experience. And because of that, I invite you to be paying attention so you can ask and they can do their interventions. Viewers, Priscilla and Rodrigo and Alan. We will start with Rodrigo, Priscilla and Alan. Each one will have approximately 10 minutes to speak. We are going well in terms of time frame. Our idea is to leave some time open for questions and answers afterwards. And we want to give the floor to the audience. And we recognize several partners from organizations of civil society, from agencies of the justice system, and not only in terms of Brazilian organizations, but also international ones who are that are present here and that invited to help us in this debate based on their knowledge and expertise. And in terms of custody, justice, prevention of torture, they are all invited to ask questions through the question and answer tool that we also have here, but they can also ask their questions through the chat and we'll be able to read them and have them translated to our guests. And then I'll come back to my mediator's position or take on my mediator's hat again. I will now give the floor to the audience and answer some questions. And I will call our speakers to work with us. We have Vivian Pence, who is coordinator of projects from the Defense Institute, and she has been a very strong and permanent partner this year on the discussion for the launching of Observa Custódia. And once again, we would like to thank her for leading all these process and for her cooperation in this debate today. Our first question is linked to the following topic: the civil society, mainly Connecta, and so IDDD, Connects, ITCC, among the other organizations and other institutions have been trying very hard on this last 7 years to monitor custody hearing. How do you at IDDD analyze, in light of this previous research, the data collected by this first experience of Observa Custódia on safeguards, services, and structures in the implementations of these hearings in Brazil? Do you identify differences that are significant or not on the historical patterns? Thank you very much, Fabio. Good morning to all of you who are following us here today. And I would like to thank the speakers who are here with us, and like to thank them for the partnership, and APT and Sylvia and all my colleagues here. We've been and Fabio, we have been talking these last months for the development of this form that brought up these number of questions to state organs. And this partnership is extremely important for IDDD, and we have talked to custodial agencies and examined them for over 10 years. We have been following their activities and also for their initiatives, and talking to them. And since 2015, when we signed a cooperation agreement with the Ministry of Justice and the Justice Council, we have been monitoring these hearings in the country and have been monitoring them, how these hearings take place, as well as the discussion they have raised, such as the discussions on the progresses made, the recent achievements to ensure rights, and the justice associations and defense association. We understand this is an important tool for the monitoring and also transparency of data. This partnership is extremely important for us. So I would like to thank you for the invitation to take part in this discussion today. To answer the first question that Fabio is asking me, if there are significant differences based on the data that was initially collected by the platform, I would like to analyze some of the information that were available related to researches done by DDD and the perspective of having access to justice and to counsel. I will not speak about all the data because we have so much data. The main significant difference, as was said, and there's no doubt, is having those virtual or on video custodial hearings, which we'll talk in depth afterwards. When we talk about the safeguards and structures, we see a new historical structure, but it's already linked to researches and criticisms that were raised by DDD before and other agencies. The first thing that we can see in the data is a lack of standardization with regard to the places where these hearings are conducted. In most capitals, these hearings are conducted in the headquarters of the judiciary powers, but there are places and cities where these hearings take place in prison institutes or other agencies. We have saw that in 2015 to 18, and we started examining these public hearings in Brazil. Even though 100% of the capitals make it possible to have a previous conversation between the counselor and the the detainee privacy is not yet ensured yet. We see that in the public defender's office, as well as in other systems, the conversation between the person in custody and the counselor, the defense, is not as yet a private conversation. And we see that the answers show that a great deal of the meeting that is being conducted either takes place in rooms without privacy, or in corridors, or in prisons, cells, or in virtual places, showing that we have not been able to ensure the privacy of these conversations between the defendant and the counselor. And there should be a reserved room in most of the capitals. However, in very little but still a small number at the resolution of CNG in 2015 that regulates these custody agencies speaks very plainly about these privacies. Therefore, we see that there is no following of this resolution as yet. Why do we see something very severe, very serious? Because this conversation is not only important in order to have an explanation in which the council will explain to the detainee, the person in custody, how important this moment is, and what are the rights and all, but also to explain and ask for questions about, let's say, the health screening and the state of the prisoner to avoid violences. When this conversation takes place before third parties, especially custodial agents, or in corridors, it might affect the narrative of the detainee, as well as affect the defense strategy. And this is a pattern we see repeating itself when we compare research done before, as well to the data that the platform brings us. And also there is the pattern in publicity of the act, and the possibility of having the custody hearings being followed by external agency. This has been done in virtual platform, and at least in 30% of the capitals, the link is not shared with anyone. And why do we say this is a pattern that repeats itself? When IDD goes in the field to observe custodial hearings in these three distinct moments in which we followed these hearings, the IDD had a great deal of difficulty to access these custodial hearings with researchers, even having an agreement signed with the Ministry of Justice, with Synergy, that obligated itself to follow these hearings. We had a great and authorized participation. It was very difficult to access these hearings in many places, especially when they were conducted in prison centers. Another data has to do with the use of restraining equipment. The collection of information given by Observa Custódia shows that the having the detainee handcuffed during the custodial hearing is a habit. It's not the case in capitals, but we see STF rules that are not being fulfilled here. The use of handcuffs must be justified, and it also disrespect the federal constitution, because we presume the detainee to be innocent until tried. And having already a lawsuit against one person puts against this person a presumption of danger and the culpability. So this also goes against the federal constitution, and as well as the Federal Justice Council, in which there is this handcuffing is specifically prohibited unless there is risk or danger presented by the person in custody. And what is bizarre is that when we cross information on the use of handcuffs, always or sometimes or as a rule, with the information of how the custodial hearing was conducted, we see that most of the capitals that use handcuffs, we see that the custodial hearing takes place virtually. So when we monitor the hearings that took place face-to-face, most of the time the justification that was very generic, because they never contemplated the concrete, the practical side. It was something very abstract that was applied. In Sao Paulo, for instance, there was a system stating that custodial hearings the place like many other forums in Latin America, where this kind of habit was the norm. So it was necessary to have people in handcuffs to ensure the safety of those who were present. And we see it is easier for people to be handcuffed, but this takes place even if they are in handcuffs, especially if they are in a virtual room. There is no one to threaten. So we see a standard that is repeated, and let's say an increase of these very serious fact. I'm sorry if I interrupted you. And this is, we have a second question regarding that. Well, for IDDD, 71% of the capitals, I mean, 19 of the 27 capitals show that people go through a virtual legal custodial hearing that we understand to be hybrid or virtual, and the person is in custody, and they can, most of them say they can adopt the virtual model. And in 15 of these, this is the only model adopted by the Justice Court. And as was said before, this does not take place before the pandemic, but it has consolidated during the pandemic and even after the emergency situation was revoked. And what are the safeguards for the person in custody? And especially it has to do with the return to in face-to-face system that generate a new system for CNPJ. How do you see that? And the virtualization in hearings is not even being debated. It is being put in practice since in the penal code, we see that there is the rule that is installed in 92 was already being followed when we had international treaties that are being respected, such as from the American Agency for Political Rights. Then all these are already disposed on taking the person in custody to the judge. So this put the we expect these hearings to take place even in the state of emergency for public health. But this is expressly exceptional when it was stated in the pandemic, and it was obligatory. But now with vaccination and distancing, the use of face masks and the carrying out of public events, there is no reason for these custodial hearings to be conducted virtually. Its virtualization should only be justified case by case and ad hoc. We know that it is possible they will take place virtually. The platform shows that, and it shows, however, on the platform that most cities are going back to the face-to-face custodial hearings, and there are several reasons for that. As I said in the beginning, the custodial hearings is one of the greatest achievements towards preserving rights and ensuring the safeguard of the detainees, because it assures the personal contact of the person with the public attorney's office and the defenders, and there is an analyzing of the legality of the imprisonment. There is an analyzing of why the person is in custody, and it is directly linked to one of the most important things, which is freedom. And this custodial hearing allows the interpreting of several conditions that took part and that led to detention. So it's extremely important to have these hearings in order to preserve this. When this presence is not ensured, the trust of the detainee may is at stake because it may not feel comfortable, it may not denounce illegalities or violences or violations. And virtual hearing makes it difficult and makes it basically impossible to see the damage or the marks on the body of the person because of the angle in which the person is placed or the lighting. And so the judge will not be able to see what is taking place. When the hearing finishes, the person may return to custody. And if this takes place in a prison center, there is no assurance that the person will be observed and taken care of, even because the rules on custodial hearings have not been fully respected. We see the pictures of those custodial hearings. There are not enough cameras spread on the room, so all that the counsel sees or the public attorney sees is someone recording the person, but we do not know if that person is being forced to say anything. And one of the main reasons of the hearing is precisely judicial. The word of the victim or the detainee is extremely important, and it's important that the person feels able and safe enough to tell about the situation. Otherwise, that person won't be able to share that. So I think that was highlighted quite often, and we highlight our concern about that, especially relating to violences that take place during the imprisonment.
Thank you so much, Dr. Vivian. We count on the efforts of IDDD for this phase that is to come, that is to bring a new round of data survey to understand how much this scenario is being maintained in the virtual hearings after this determination of CMJ. I believe that we have the tool Observa Custódia has this role of maintaining the safeguards. I ask you to remain here so that we can answer the questions at the end. Thank you. I will give the floor to Mr. Rodrigo Pacheco, who is the Public Defender General of the state of Rio de Janeiro. Rodrigo Pacheco has been a great partner in the last 2 months, especially engaging the public defender's office all around the country, asking the defenders to fill out the forms on custody, and as when he was the president of Condege as well. So I'd like to thank Mr. Rodrigo and the Public Defender's Office of Rio de Janeiro, who have been supporting Observa Custódia in the development of the platform and also in including data. So I invite you to open your mic, Mr. Rodrigo Pacheco, and I'm going to ask the first question now. I don't see Mr. Rodrigo. Here he is. Thinking about the patterns that were adopted nationally, the data revealed by Observa Custódia in this survey and in other surveys around Brazil, although the data revealed in this research differences in the models adopted in each capital, it's necessary to emphasize what can be assumed as nationally adopted practices and positive, since in all capitals we identified they are all hold custody hearings every day of the week, including holidays, and in all capitals, the persons in custody can talk to the technical defense before the hearings. I'm not talking about the quality of this access to defense, but they have this access to defense. 7 years after the custody hearings began, how do defenders follow up and evaluate this development? Thank you. Good morning. I'd like to start by greeting APT, especially Silvia and Fabio. They are old partners of the Public Defender's Office in Rio de Janeiro. I'd like to congratulate for the dialogue. This fantastic work is a very, very bold and innovative work, and very important for us to defend the public hearings. And my friend Florisvaldo, he brought together Condege with this 27 Public Defender's Office, and we are proud to announce that we were able to engage all the 27 Public Defender's Office with the partnership of Florisvaldo and IDDD. IDDD has a historic role in custody hearings, and we must highlight the importance of this partnership at CNJ with IDDD. And with this brief evaluation, I would say that we had four phases in the custody hearings. They are phases that overlap one another due to the dynamics of each state. But I believe that the first phase starts in 2015, and it's important to highlight fundamental institutions such as IDDD and two people who were very important for custody hearings. One is the Justice Lewandowski. When he takes over the the National Council of Justice, he has the political will of implementing the custody hearing. If he didn't have that will, we would be debating on how to implement the custody hearings. And an executive person that is working with the judiciary branch is Lanfredi, who is also very important for the criminal justice system because he was an incredible person with great dialogue and great strategy because he starts with the state of São Paulo, and this is the hallmark of the first phase, the choice of the state of São Paulo, a giant state with the greatest prison population, one of the most conservative judiciary in the country. We should observe the number of habeas corpus writ of habeas corpus, and a great deal of them is due to not compliance with the decision. I don't live in São Paulo. This is a very shallow analysis, but it seems to me that it was a great choice. He chose the right strategy, the right leaders for the process. So this first phase was to choose the strategy. Of course, everyone here was defending custody hearings. We understood it was applicable, but we didn't have a norm that could foresee custody hearings. Rio de Janeiro was living that trauma from 2014 because in Rio we had a norm that every inmate should go to the forum to receive their accusation. They were interviewed by the public defenders. We could initiate their defense, but after this first event, the Court of Justice prohibited that, and it was very hard to exercise defense because the Court of Justice said that they wouldn't send the inmates to the forums, and that ended this possibility of a technical defense. And it's very hard for a public defenders who have hearings 4 times a week to go to the prison to have the interviews. So we started defending the custody hearing, and I believe that all the Brazilian's public defender's office were involved in this defense to combat and prevent torture. Rodrigo, uh, I would like to take advantage on your comment to advance in this question that we have for you. Thinking about the different models for custody hearings, there are many regulations on custody hearings which are advancing but we see that these practices are adopted in part of the capitals, and in some capitals they are not even adopted. So reflecting about upon these practices and implications, we see that the use of handcuffs, cuffs and other containers during the hearings, they are present. We have great high rates. We have 13 capitals, 48% of the sample, and the person in custody is submitted for this kind of containers. Besides, in a smaller proportion, we see the use of uniforms, prison uniforms during the hearings, and that has been very meaningful because the wearing uniform is a habit in 6 capitals, 22% of them. And concerning this last point, referring to the place where the hearings are happening, data show that the responsible body for the custody hearing is a court of justice in 59% of the cases in 16 capitals. And the prison administration secretariats are responsible for 6 capitals in terms of custody hearings, almost 20% of the sample, and the civil police is responsible for 7% in 2 capitals. So the custody hearings are happening in this civil police station. So how do you analyze the efforts to implement custody hearings from different actors? The actors of the criminal justice and prison execution, and how do you believe that these different models can imply in different custody hearings and defense works for the people in custody? I'm going to talk about the second stage, that was the fight to have hearings during weekends, and the Supreme Court advanced a lot in terms of preventive arrests, detecting illegal arrests. So we started the pandemic. We had several strategies adopted in Rio de Janeiro. In Rio, we adopted the suspension of custody hearings, not to have video conferences. And maybe this strategy was the right one, as we observed after the pandemic, because where we had video conferences, the custody hearings are now still happening. We were criticized at the time. They told us that it would be better to have video conferences than nothing, but we didn't accept video conferences because we know that when a setback established, it's very hard to advance again. So Rio de Janeiro doesn't have video conferences today. I'm proud to say that. We have many contradictions in Rio de Janeiro. We have conservative actors, but thankfully we are 100% face-to-face in custody hearings today. But the different bodies are making a lot of pressure, especially the national judges represented by AMB. They have uh, been pressuring us to establish video conference. And the, and due to the custody hearing debate, they they talked against that they said there was an increase of violence and they attacked a lot this custody. And we have to understand how it's going to advance. We are firmly opposed in Rio uh, to custody hearings via video conference, but when sometimes people defend and they have good reasons. But in our opinion, we only have 3 to 4 states with public defenders offices in all the municipalities, and we have great states, and regretfully, the free defense is uh, is not happening in all of the places. And when we determine in the states where the public defender's office is not covering everywhere, that it's 100% face-to-face, the private lawyers are going to occupy these spaces. with the video conference, the public defender's office are able to do all the custody hearings. So it's a difficult choice. We defend face to face, but uh, at the same time, with that, we are strengthening the private lawyers. I know that we have the public defender's office that could have face-to-face, but they are doing video conferences. But this is an important debate. How should we advance in this scenario of fiscal crisis? It's so hard to advance with public defender's office and how to provide a quality service. If you observe the community of Benfica, there are many private lawyers trying to obtain new clients for custody hearings. And considering handcuffs, we have this punishment culture here. And I'm trying to understand what's happening. I'm not telling what's right and what's wrong, but we have battles to face. And if you face all of the battles, you're going to lose all of them. So maybe in this dynamics of custody hearings, defenders are seeing that as a smaller battle. Or sometimes they require the removal of handcuffs, but the judge is willing to keep them in handcuffs because the prison system is managed by the prison administration, and maybe the judge would like to maintain them in handcuffs due to safety, and so on. And just to wrap up, because I know that I should talk about the models, the worst model is with the civil police. This is clear to me. And I'm doubtful if the custody hearings within the prison systems, if they are so bad. To put the judge inside the prison system, it's a gain, in my opinion. And for the person in custody again, as well, because we see that many people in custody, they request not to go to the instruction hearing to prevent the transportation and the vehicles of the prison administration. So we would have them transported to the forum once more. So there are some issues that could make us understand that not always having that in the judiciary branch is the best option. Maybe within the prison system is best to put promoters and judges within the jail for them to understand what's happening there. I'm trying to summarize. I won't take more time than I should, as public defenders do normally, as it's the common joke. And I think this is the most important part of this story, the post-pandemic. Where should we advance to? Are we able to remove video conference, or have we lost this battle? Thank you so much for the invitation, and congratulations, and count on us to advance with Observa. We thank you, Rodrigo. You spoke in under 10 minutes and you were able to highlight important issues, many different dilemmas which are hard to face. And only with access to information can we understand the reality. So I believe that the tool Observa Custódia will enhance the discussion, refining the analysis for us to understand this kind of developments that you brought to the discussion. So I ask you to stay to the end, until the end, to answer the questions from the audience. And I'd like to invite now Mrs. Priscila Serra, if you can open your mic and your camera, reminding you that we have the Q&A tool open if you want to participate in this discussion and take advantage of this great moment when we're able to put together important actors in this debate of custody hearings. And I'd like to invite Mrs. Priscila Serra to be part of this panel. She is the national representative of the National Agenda for Disincarceration. She helped us during recent debates on the creation of Observa Custódia, and she's bringing the opinion of civil society, family members who are affected by incarceration in this diverse territory with different realities in Brazil. So the agenda for disincarceration is a strategic actor to support Observa Custódia, mobilizing data and different partners in different places. So I'm going to ask questions to Mrs. Priscila Serra, and the first one is concerning the conditions of the public hearings. These conditions are key to ensure a hearing that is proper for the person under custody. This is key for custody hearings. The In the Observa Custodia survey, we see certain aspects that can generate concern. For example, in relation to the presence of security agents inside the rooms or being able to hear what is said in the room. In 71% of the cases, these officers are present or as a rule present at the hearing. In addition, we see that access to family members is still limited, as Vivian said earlier. Only in 9 capitals do family members are able to access the custody hearings. And in the case of virtual hearings, the technical defense is not regularly in the same room as the person in custody. So the first question is, how do you evaluate the scenario for a proper hearing? And in concerning psychosocial care, we'd like to delve into this issue and the different units of custody hearings, because it's a service that is indicated by Resolution 213 from 2015. We see that in 8 capitals, 30% of the places, these services are not offered. If if this is the reality in the capitals, it's possible to understand that it's even more difficult to happen in the country as a whole. So what is the importance of the psychosocial care for the person in custody and their family members? And what is the role that they play in this moment of the first hours after arrest? Thank you, Fabio. I'd like to thank you on behalf of the National Agenda. It's a national movement. We have 19 state fronts for disincarceration. We've been growing a lot, and that enable us to contribute for the development of the platform. Concerning psychosocial support, this is key in our opinion. And why is that? Because when people are arrested, and even when they are approached, and it's very complicated to talk about police approach, because in reality, what's happening is that people are being hijacked by the police officers, and the custody hearings are going to happen only later on, and 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 they have to wait until that custody hearing, and the family has no access to them, and nobody tells them that they are not alone, that they can be safe, that they can have psychosocial support for them and for the family who are trying to find this person who was arrested by a police car. So this psychosocial support is key until the public defender is able to arrive in the police station. We know that most of the people who are arrested are poor people. They cannot pay for this private defense. So we have psychosocial services at VEP. In the Amazon, at least, we have the social support of the Court of Criminal Execution. And this is something key for the family members of people in custody. It's 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 how people are able, it's the avenue open for people to talk about their problems. So the psycho secretariat should include more people in their studies. For instance, people could say, my husband has been arrested, I am unemployed, my child is sick. So this service can select the priorities, and this choice is concerning the behavior, but we don't understand the criteria very much. They say uh, they, that depends uh, on if the person under custody has tried to escape or not, and so on. But people look for the psychosocial services within the unit, and they also seek for legal advice. And sometimes they say, I need to work, I need to study, and today they only have a right to sunbathe. They are always in crowded cells, all this context that we know. So these people who are in custody, they are trying somehow to do something, but we are not able to advance with the secretariat, with the prison unit. So the families are going to the psychosocial services in the support of criminal execution in the Amazon. Now it's the only way we can find help somehow. And it's the only way for the relatives and for the person in custody. Concerning the support within the prisons, how can we imagine a person who is side by side to you and who has tortured you? And how can you tell the judge that you were arrested at 8 p.m. and now it's 8 a.m. and I have experienced torture, I was beaten, and with the police officer by your side or listening to what is being said? So the person is totally oppressed. It's no secret that the physical torture is happening, also the psychological torture, and they are trying not to leave marks in the person, so they try to suffocate people, and people choke. I'm going to give an example. They use Coca-Cola. They throw Coca-Cola in the throat of the person. So this kind of torture is not able to be, we are not able to detect. And people do not feel safe to speak. They won't complain when they are close to the police officer or close to any police officer, because here I'm in a safe space. If I'm going to, if people is complaining about Sylvia, we know you will maintain me safe. But it's not the case when you are in the police station. If there's a police officer close to you, you're going to tell to the other police officers. And this is clear. Janine just said that. It's an attempt to end custody hearings. It's an attack that we are suffering because it's the only means for the person who was arrested to denounce, to complain that they were tortured. And it's the only means for the family as well. I'm a family member of a person in custody, and when my relative was arrested, I didn't know that I had the right to follow up. I didn't know that I could attend the custody hearing. I didn't even know the time. And that's happening all over the country. And they use this ignorance. Uh, and it's a crime to hijack a person, taking the person to the police station. And no one else is able to go into the police car. So we go to different police stations and we cannot find our relative, and they are sent to custody hearings, and we don't know where they went. We don't know what that is. In police stations, people refuse to provide information to us concerning custody hearings, about the times. People do not have access to this information.
And somehow we believe that this is means to actually inform the family members and relatives, and for people who are the periphery. So we always are aware of that. You have been approached by the police. You can ask to have a hearing or to get counsel from a public defender. You have to ask it, and you can say, you can state, I do not want to make a deposition. I want to speak to counsel or to the public defender, but they are forced to. Then there's go on to the public hearing, and then in the custody hearing, there is another person who tells you, okay, you said this, this, and that. This is in your statement. And so you get into another kind of problem. How are you going to say in front of an inspector or a policeman or anyone in a position of power that we're forced to make a statement? Sometimes I was not even forced to do that. I just sign a document, and then I go to the judge and I tell the judge that this is something that happens in our country. I was forced to do that. I do not feel safe to make a statement before the police. And people do not accept this statement in the custody hearing because the statement was made in the police station, and you wonder, what am I going to say to that boy or girl or teenager that they were not forced to do what they did? And when you ask them, it's like, did you make a statement? They said, no, I didn't want to, but when they go to the courts, people get another policeman that talk to the other policeman. So they may not have a relationship, but they know, the policemen know themselves as comrades. This generates insecurity. There's no way you can fight this in prison units where you have the custody hearings. Not even virtual visits are allowed with privacy, let alone face-to-face custody hearing where the person in detention is being tortured physically or psychologically, because when the detainee is taken to a cell, okay, you have you know, when you have custody hearings, this is the room. People are taken to a prison unit, and there they will be taken to a room which is very well equipped, according to people, in which you have access to the internet. Everything seems okay. But who is taking that person to that room? Who is accompanying this person to that room? And then you have to hear the excuse that people are there to help the person who is in the custody, because they are wearing handcuffs and they are in the prison units, and often they have their feet cuffed as well. And I asked the question, how is someone supposed to escape a prison unit with their feet cuffed and their hands to, and they tell you, it's okay, if you press this, you will speak, and if you press that, you will stop speaking. Why is it so simple? Because to monitor the person who is speaking, just as they are monitoring the virtual visit, to prevent denunciation on psychological or physical torture by people. We have reports of people who got shot or who were lynched and are in a prison unit waiting for the custody hearing, and they are unable to say, I feel pain, I'm in pain, I was taken to a health unit, but I came back and I'm feeling a lot of pain. And they do not denounce that. They cannot say that because they are in prison units. And who can they tell that to? Only to the legal power. It's easier for the legal power when you say the things were made easier, but for whom? Actually, only for the members of the judicial power. In Amazonas, in the north, most of let's say, the ways to the means to arrive a place are waterways. You take a boat, which is a slow boat. It takes you 12 hours. So we go to the hinterland, and people have no means to have access to custody hearing. It's a virtual hearing. They are taken to the main unit in the prison center, and we have data of all the prisons, especially in the municipality of Tefé, in which we saw physical torture. And we have the reports on that. So where was public defense there? They tell you that the person states that they were tortured, and this is recorded. But what happens afterwards? There's no means they can do anything. The public attorney's office won't do anything. That person will not have any right to any psychosocial following for them to understand what is happening, let alone the family. We are talking about the 30, 40, 60 days without the family being able to see the person in custody. When they are able to visit the person, the marks on the body have disappeared. And so we have seen people limping because they were hit with pieces of wood. They were strangled, but these marks will disappear. And I asked myself, how can you say that virtual custody hearing will achieve all that they propose to achieve? At the minimum, you expect that if you have someone here in front of you with a black eye, limping, and the arm in a sling, people will ask, okay, what happened to you? That's the very least, because the person will not state that spontaneously, not especially not in front of a policeman. So how will the judge be able to identify that I'm coming to a prison unit limping, and that I'm coming to the video room unable to walk, that I have marks on my head, or that I have a purple mark on me? They are unable to do that. And so they cannot say it makes things easier. It the custody hearings that are virtual facilitate physical torture. And I'm sorry, I went over my allotted time. You brought up very important denunciations that bring up our responsibility. We are all involved, and we need all to act against that. We have knowledge of this kind of thing happening. And all that you said shows the importance of setting aside the number of the debate on people who were arrested, and how many people were in provisional detention, how many people had a custody hearing, and to see all the aspects involved in custody hearing. That has been the civil society's paramount effort to monitor these hearings. However, these patterns that you just mentioned, these patterns of violence and torture, and the incapacity of rendering service to those people have shown the problems that arise from the virtual hearings. Thank you very much for your intervention. I will ask you to stay until the end for when we'll have the questions and answers. And I would like to thank you on all the persons who were composing this network and who you are representing today, and that help us in the platform of advocacy for the promotion of the justice system. So thank you very much for your help. So now I call for the last intervention. I'll call Mr. Alan Damascenos, public defender in the state of Pará, and he will be able to complement what Priscilla has just said. And we would like to thank the Public Defender's Office in the state of Pará, which was one of the states that allowed us to talk the most to public defenders and defenders in general. To everyone was extremely helpful, extremely enthusiastic. and had a great deal of knowledge on the Observa Custódia and wanted to expand this beyond Belém, the capital. So this gives us already our first question to Alan, which is that despite the efforts or attempts to standardize custody hearings in Brazil and also the court decisions and CNJ resolutions, we still observe very significant differences in the way these are implemented in Brazilian capitals and in the hinterland. So although it's possible to think that some flexibility in the implementation may be beneficial to the plurality of Brazilian reality, some capitals and coordinators, centers take turns in carrying out those custody hearings, following the model as we see as more atomized, with each criminal court holding the hearings in its respective hearings in its own way. And even though we can salute or greet some kind of flexibility, we cannot flexibilize some safeguards, measures and services, and we have to see that they are implemented. So what is the model adopted in Pará today? What are the difficulties that you face and what has worked? The second question I would like to ask, which is linked to another topic brought up by Priscilla, we would like you to comment on the carrying out of health screenings or forensic examinations prior to the custody hearings. Data shows that the results on these exams are only made available in 13 capitals. Basically 5 capitals that are represented in 40% of the capital. In 9 of these capitals, this exam does not reach the authorities and does not reach these authorities before the custody hearings. So we can have, what are the consequences that this can have for the defense of the person during the custody hearing, and what are the consequences it can have, and how can we monitor these denunciations in specifically in this very important moment that is custodial hearing. And you have the floor. Thank you. Thank you very much. I hope you can hear me. And good morning to everyone. I would like to thank Silvia and Fabio for this opportunity. This is a very important moment to take part in this discussion. The development of this platform is extremely important for society and for public defender's office in, specifically. And I would like to thank all that are present here in this panel, Priscilla, Vitor, and all those who contributed, and say that for me, it is also extremely important to be part of this event. An event of such magnitude. I would like to thank APT for the way in which they are conducted this event, as well as Silvia. And I would like to thank about tell you about your reality here in Pará. Brazil is a very large country with continental proportions. So it's interesting to see the several different experiences that we have in the territory. Since 2015, the Public Defender's Office has tried very hard to carry out those custody hearings so that we can really be present in all these steps of the legal procedure. In Belém, we have, I'm in the coordination of this group, and we have public defenders that are specialized in custodial hearings that take part in the groups. They are directly linked and designated to work only with custody hearings. In our court, we have our criminal court, in which we had only one position for the criminal branch, and we have these persons that are in charge of following up and monitoring the custody hearings during all the steps of the procedure. And so we give importance to this custody hearing. This is the first entry of the detainee with the public defender's office and the council. So we try to use all the April we can to carry out all these custody hearings in the capital. We have hearings from Monday to Friday in Belém, and in the capital, we are part of all the hearings in which we see that the detainee is vulnerable or needs counseling. So we are quite well equipped in Belém. In a way, we have a very effective participation in this custody hearing. We have direct contact or direct channel, actually, to support the detainee's family, to give them documentation or to give them information that will make it easier to obtain information during the custody hearing. We also have a daily conversation with the criminal courts, and we have obtained a great deal of progress with regard to the use of handcuffs during the hearings. This is one of the main problems that we still have today. Often we see the person in custody wearing handcuffs, and we have been able to change this situation. Of course, during the pandemic, this situation was a little harder. This has changed now with the end of the pandemic, but often in the virtual environment, we saw the detainee wearing handcuffs in the virtual room, and we had to question that and raise that. And this was a difficult moment, but we had important developments, and a great deal was the effect of these equipment and monitoring that we do. So we have this constant follow-up and monitoring of the detainees during the whole process. The major problems reside in the hinterland of the state. If in the public defender's office, if we are not available, we are unable to follow everyone and all the cases. Recently, we had the designation of the 35 new public defenders, but we are still well below the number of defenders that we need for the municipality and for the states. We have a very low DHA in many centers, and the sitters, because of a lack of public defenders, will not be able to have the custody hearing. This is due to a lack of a budget. Quite often in Pará, we are unable in the public prosecutor's office and the judiciary system to have a higher budget, which makes it difficult to have these custody hearings. Even though we have made progress and we have increased our numbers, these defenders that are in the state will be spread in 2 cities, unless, and this allows them to cover all the hearings, but we leave other cities without coverage. Another negative aspect that I see that has not been broached yet, and has called my attention, is how the detainee is taken to the custody hearing, how they are taken there. And this we see not only the custody hearing, but when we visit the detention centers and prison units, and have seen that other states go through similar situations, but are doing better in Pará. When the detainee is sent to the custodial hearing room, they have to walk with their back rounded. They cannot look to the sides. They have to look at the floor. They are basically taken. They are unable to walk freely to the custody hearing room. And we have seen that quite frequently. The penal system superintendents say that this is due to safety and security measures, but they are disproportional, because when you take a person to a hearing, there's no need to have this way of taking people. You cannot violate the international conventions, and take the detainees to the rooms in a very disrespectful and disgraceful ways. So this is an important aspect, and the public defender's office in Pará has talked to the courts and the prison centers to try and improve this way in which the people are taken to the custody hearing rooms. And this is an aspect that leaves a lot to be desired. And people can say, oh, this is just a complication of the system. But no, you have to give the detainee his or her dignity so that this person can talk freely and has the conditions to say or state the facts or denounce torture. How will they be able to do that if the way in which they are conducted to the is already degrading, in which the person cannot walk freely, has to look at the floor, has to look with the walk with their back rounded. So this has received a great deal of criticism in our state, and we are trying to solve that. This goes, they say people, this goes against the safety rules, but I believe we make progresses, and the platform is important for us to have this kind of exchange and to raise this kind of issue that take place in our state. Here in the capital, generally speaking, we were able to solve this issue of the handcuffs, more or less. But in the hinterland, you still have this kind of case taking place. Often, people will not be able to participate in custody hearing because of a lack of public defender, or they will try to have a face-to-face, a private meeting, but this hinders the legal assistance to the detainee if the defenders cannot reach them. And also this is related to the health screening done by policemen that have taken a long time to be sent by the police and do not reach the defender's office before the hearing, which does not allow us to see if there was some kind of physical aggression or torture on the person. This is the idea of the health screening or forensics examination, in which are able to observe the state of the detainee. So we have had this kind of problem here in Belém. Generally speaking, many cities, many states have faced that problem, and it's not different here in Pará. I'd like to thank you all for the invitation. I believe that is the information we can share on Pará. As I said, Brazil is very large, has many different locations. So this platform will allow us to share our experience and will help us solve these problems and be also able to exert pressure to have better custody hearings. Thank you very much, Mr. Alan. I think the state of Pará is representative of this dimension of Brazil, and your presence here is very representative. We would like to thank you all the effort that was made to answer these forms. These not only right now, but also in the following moments for our platform in which we monitor custody hearings. We will wrap up the first part of this discussion panel. And for the final steps in which we'll have Q&A, and we will wrap up, I would like to invite to join me, my colleague Silvia Dias. Thank you very much to all of you. Thank you. Thank you, Fabio. Thank you, all the speakers for their interventions and all the ideas they raised. It is quite clear that this is a very complex subject. And as Rodrigo said, there are many crossroads that have to be faced. We have here two questions in our chat, and I would like to share them with you. The first one is essentially from Cristina Villanova, essentially directed at the custody hearing, how do you deal with the torture, and also how the platform could approach this. The question is, she says there is a great difficulty to check these denunciations of torture or ill treatment during the custody hearing, and if they were properly examined and with a lead to an investigation. Will Observa Custódia have a field for the analysis of that kind of results? And I will share with you our opinion. At the moment, we do not have this specific field, but the idea is that this tool will evolve and will allow us to see better ways to use the tool and get more knowledge. So that could be a future use of the platform, trying to apply it to some states and do the monitoring through the platform Observa Custódia. Right now, we have examined the conditions of putting it into operation, the forensics exams to be used that will help us in seeing the state of people. We do not have yet this monitoring of the results in our tool, but it will be interesting to have that, and maybe our speakers could share with us how they see means to implement that as a further tool for us to monitor the cases and see the progresses or not. And the second question is by Greg Main, who brings up the link between the custody hearings and the preventive detention. And he asks, custody hearings have been successful as a tool to reduce the number of people that are detained and sent to detention prior trial. And they have had success as well in decreasing the number of the prison population. And he asks whether the platform or if there is any other study that shows the difference, for instance, in the pretrial release rates in terms of different races. I would like to give the floor, give the speakers the floor to answer these questions. Maybe start with Vivian. Thank you very much, Sylvia. I was going back to the data published by IDDD, and in the first research we did, which refers to data of 2015, 2016, and I can make them available. I can send them so they are shared. We can make these comparisons and a comparison, in 4 capitals that we have monitored: Minas Gerais, Pernambuco, Rio de Janeiro, and São Paulo. And we see the information that in all these states, there was a rate of pretrial detention of Black people that is higher than that of white people. In Minas Gerais, for instance, we had pretrial detention for 23% of white people compared to 78% of Black people. In Pernambuco, white people were kept in pretrial detention of 8% of the cases, where 92% with Black people. I'm sorry, I'm making a mistake here. I'm looking at the whole numbers and not also in Minas, 42% white people in pretrial detention. That was the first monitoring compared to 70% of white people. 77% of white people against 70% in Rio de Janeiro, 52% of white people and 66% of Black people. In São Paulo, 55% of white people against 61% of Black people. So Black people are always more represented in pretrial detentions than white people in the first monitoring. The second one that was carried out in 2018, where we covered more cities. We could move beyond the capitals where we had carried out the first monitoring. We crossed that with, due to a strong criticisms regarding the freedom that is given without the imposition of cautionary measures, or the, let's say, the state following these people. So non-conditional freedom should be the rule that should come to replace a prison in those cases in which it do not fit into the articles of the Penal Process Code. What we see in the second monitoring is that these cautionary measures come to replace freedom. So freedom, as we call that, a restrictive freedom without the imposing of cautionary prison is measures, I'm sorry, is reaches less than 1% of the people. And looking at this specific data that is not conditioned to cautionary measures compared to the total number of people that we have followed in the hearings, over 2,500, we see that 0.85% of the Black people got provisionary freedom based on cautionary measures, while the white people had 1.11%, which is a very small number, not very expressive, because these are not conditioned to the fulfillment of any other obligations. So we have over 2,500 cases with only 23 cases of freedom granted. Another question that is implied here is that it does not look like the hearings or has been granting this freedom or decreasing the prison population. In the last reports that we obtained, we see there is a growth in prison population, and these indexes of pre-trial detention in the research we did after 2018, we did not go back to the field to carry out a new monitoring of the research. They showed an increase, unfortunately, in pretrial imprisonment. Thank you very much, Vivian, for your participation and for your partnership. And now, Mr. Rodrigo, I would just like to share data from Rio de Janeiro. And I must say that I'm not as hopeful, even though we did not do a comparative study before custody. This, the latter one, did not represent an indicator of freedom. Since custody was created, we only had 1 month in the state of Rio de Janeiro, in which we had more decisions toward freedom than to keep on the detention. That was at the early stages of the pandemic, when the judicial power was sensitized, let's say, by the pandemic. And I have data from last year, which was very scary. I would say that in average, this is the case in which you have a public defender's office present in around 92% of custody hearings, and the rest goes to private defenders. It's in considering the 12 months of 2021, 70% the cases, the judge will keep the detainee in prison. So I'm not very hopeful regarding that, and I cannot say that the custody hearing represented a decrease in detention. And Brazil is getting the award as a country that imprisons the most. I would like to share a data that called my attention in Rio. For each 10 person presented, 3 present ill treatment marks. And if you analyze these 30% of detainees who show marks of torture, of those 30%, 80% are Black or brown. So in addition to receiving a more strict treatment on the part of the law regarding freedom, of each 10 person who suffer ill treatment, you have 30% that have that are tortured. So Rio de Janeiro, generally speaking, has reduced the detention after the pandemic. Before we had 52,000 people in detention. Now we have around 47 to 46,000, but this is not linked to the custody hearing. That is a hearing that takes place during the penal enforcement. And we have people who are enjoying some kind of benefit, let's say, that were able to leave detention during the weekend, are now free and able to have detention at home. Thank you very much, Rodrigo, for raising the data from the Public Defender's Office in Rio de Janeiro. And once again, I would like to give you my thanks for this partnership. Since the beginning of Observa Custódia, you have always been there, you giving us your support. So once again, thank you very much. And we go on ahead together. I would like now to give the floor to Priscila. I already have the answer from Vivia and the public attorney. There was no decrease. There was some improvement during the pandemic after recommendation of this Supreme Court, but people were already in detention. You saw this decrease and this increase of freedoms granted. In some states, it was different because they imposed the system of distance monitoring through ankle bracelets, in which people were monitored from their home. And there is another issue, which is the fact that these ankle devices did not work. There is an the information is given by the person who is in at detention at home, and even and they update their address, but the system does not update the distance, and the person is considered as trying to evade the system, and these people who are in prison are considered at fault, and they will not go through a public hearing, custody hearing. They will not be able to get support, and they will have to, if you send a message, it will take 10 to 15 days to be able to get an answer from the system. In the meantime, all the legal terms keep on moving forward. So you do not actually get these custody hearings for people who are using electronic antlers to monitor them. So this is another drawback from the legal system. Detaining people is always the last option in the law, in the eyes of the law. In actual life, this is not what takes place. And despite what society say, that when people are freed under conditions, they're on the parole, we know that this is not true. We know there's an attempt to put most of society in detention. As I said, often when we talked about prison population, we're not speaking just about people who are in the prison, because the family follows them in the detention system, either because their human rights are violated or due to psychological violation of their rights. And the family members are not aggressed physically, but they also go through all the difficulties that the detainees go through. I missed a little of the third question or answer. The third question? I'm sorry, I didn't hear you. The third question, you were it was precisely on that, if there was a larger detention for people based on race compared to white people. Well, yes, this is exactly that. And I feel that in every place of our country, in the approach, or either you accept the detention or they throw you on the floor and they detain you. So this is why it's so important to have this movement and coalition of which you are part, network of people against violence, and your activities and initiatives, and also your mobilization. So once again, thank you very much for taking part today in this debate. And finally, I would like to give the floor to Alain for final considerations. We have gone beyond our allocated time. Of course, the custody hearing have shown that there is a progress with regards to prison conditions, but if we compare statistical data regarding the larger granting of freedom, we have not seen that, especially here. Imprisonment in pretrial detention in Brazil, at least in Pará, we have around 6,000 pretrial detainees, which is a very high number. And it's not common for us to take part in custody hearing. We know that often the person will not be kept detained after the trial, but the person remains in prison. Often they are unable to present a document or a rent slip or something proving they have a house, and often they will be condemned to a sentence to a community service. So these custody hearing have a positive side, which is the monitoring of these conditions, but with regard to the decrease of provisional detention, the in fact effects have not been very good. Thank you very much. I think the screen got frozen. Did you conclude your idea? Well, thank you very much. And once again, I would like to thank the Public Defender's Office of Pará, and I hope you'll be able to keep on contributing to the future collection of data to consolidate what we have. And Mr. Giannini asked to make a final comment. Very, very briefly, I would just like to add a few aspects on torture and racial data. We must bear in mind that collection of racial data has to be improved. We have some data that comes to our hand, but often we are comparing oranges to bananas. We don't know how the data was collected, if it was self-declared or by other means. Recently, we had a survey on custody agencies, and we try to capture the racial profile of the population. And often it is not told. Often they follow the Brazilian Statistics Institute data. So it has improved. The situation has improved the last few years, but we still need intensive work to develop those skills and standardizing those skills to standardize the data. We have a picture of the profile in the custody agencies, but the numbers are not precise because we have the gaps in the methodology to collect the data. As for torture, how it can be shown on the platform, we also have the need to see what happens afterwards. we often have the numbers for denunciation of non-recorded target, but it's very difficult to see what happens afterwards, after the hearing. We know that the number of people who are freed is very, very low. It hardly ever takes place. We have a study connected to see what happens to those denunciations. But this is another side that we have to bear in mind. We know that unfortunately, most of the cases will not result in anything, but it's important to have this monitoring. This is what I wanted to say. Thank you. I agree. Thank you very much. I'd like to thank you, Janine, and I'd like to thank you all for the partnership, and I agree. And we saw that in the questions. We have this large gap that does not allow us to understand what is happening, what are the effects of those numbers that we have seen. That you have very high numbers for aggressions and violence and torture, for instance, in Rio de Janeiro. And we want to know what happened. And that could be precisely another effect that we could work on, a pilot project using other data with the teams to approach that. I would like to wrap up here. I'd like to thank you once again for your participation, and also thank Mr. Floresvaldo, who I think already left us, but I would like to also thank Converge and also the public defenders who are here, who answered the form, who brought the information that is now available on site. And on the chat, we put the link for the platform Observa Custódia, and we shared some reports that can be of interest to those who are participating. And also I would like to share the interface of Observa Custódia. This is our site of Observa Custódia. You have the panel in which you can see the data here, visualização de dados. You can see the data on the panel. Here, it refers to virtual custody hearings, and you can see 8 states in which you have face-to-face hearings. The data was collected until September 14. You have the 5 that are entirely virtual, hybrids and mixed. And I would like to tell you that it is possible to see that per region or per city. We have here a cut per region and also per capital. You can select the state on the map that is placed here. The site, the link is on the chat for everyone to access. It's observacustodia.com, and I hope that everyone who is here can go in, explore it, and get to know the platform. And I would just like to say this is the tool that is being developed, that the idea is to make it sustainable and permanent, and that will be able to give us different aspects and stances and different kinds of data, more information increasingly, and that it will consolidate itself in the future to contribute to the democratization of data. So I hope you'll get into the platform, observacustodia.com, and if you want to share any comment, you can do so in the platform. There is space for that in the chat. Send us information, send us suggestions and comments. Even if you find any mistakes or errors, it's important for us to get this feedback. We have gone 20 minutes on our time, so I'd like to thank the speakers, Fabio, Jasmine, and the interpreters who remain here for these 2 hours 20, translating into English. So thank you very much, and we will now wrap up our event. Thank you. Thank you and congratulations.